We welcome you to this audio series intended to provide information to those eligible for Air Force legal assistance, which include active duty military members, their dependents, and retirees. Our hope with this series, which we are calling The Art of Law at Hill Air Force Base, is that we can convey legal assistance information to you that is readily available, provide information that is responsive to your needs, and to do so in a timely manner. This series is for information purposes only and is not intended as a substitute for legal advice from an attorney. Today we will be discussing dependent support for military members. My name is Brad Bell, and I'm joined by one of my colleagues, Mr. J. Ed Christiansen, the Chief of our Legal Assistance Office. Welcome, J. Ed.
Thank you, Brad. I'm glad to be here.
So oftentimes during our legal assistance appointments, we have individuals come in and say that they are in the process of getting a divorce, not quite there yet, and they're wondering how much support they should be getting from their active duty military spouse. Can you please guide us with a formula and what the answer is to that question, Jay?
Sure, absolutely. There is an applicable Air Force instruction. It is Department of the Air Force Instruction 36-2906, entitled Personal Financial Responsibilities. Under that particular instruction, all airmen are required to comply with whatever financial provision there may be in an applicable court order. They're also required to comply with any financial support provisions that may be in a written agreement. That is, a separation agreement, a stipulation, a marriage settlement agreement, any type of agreement that's reduced in writing where both parties have signed. The Air Force requires that airmen comply with those financial terms. However, in the absence of a written agreement or applicable court order, then Chapter 4 of the instruction provides a formula that is to be complied with until there is either a court order or written agreement. It's called the pro rata share formula. And without having to read to you directly from the instruction of what that formula is, the best way to understand is, first of all, you start with your non-locality rate BAH. And for those of you who don't know what non-locality rate BAH is, it is the amount, the fixed amount of BAH that you're going to get no matter where you are stationed. For example, in an area such as Honolulu, San Francisco, or Washington, D.C., where the cost of living is extremely high, the BAH is going to be very high. But in more rural settings, the BAH is going to be much lower. But no matter where you are stationed, there is a fixed portion of the BAH, and that's the amount you're going to get no matter where you're stationed. It just happens to be the same amount that reservists get when they're on active duty orders for periods of less than 30 days. It's called non-locality rate BAH. And here in the Salt Lake area, BAH is a little high, certainly not as high as Washington, D.C. or San Francisco, but it is one of the higher amounts. But no matter where you're at, the non-locality rate BAH is the fixed amount, and that's for example, an E5, an Air Force Staff Sergeant, the non-locality rate BAH is almost $1,300. Even though BAH here in Salt Lake for an E5 is significantly higher, several $100s more. But according to the pro rata share formula, you take all the dependents you have essentially and divide your non-locality rate BAH between your dependents. So to give you an example, let's say that you're married with 2 children from that marriage that are both minors, and you also have another child from a prior relationship. In this case, you would have a total of 4 dependents. 1 child outside, 2 children with, and the spouse, a total of 4. If your BAH, your non-locality rate BAH, is $1,200, to make a nice round number, you divide that between your 4 dependents. That is, each dependent is entitled to $300, 1/4 of the $1,200. Now, of course, the child from a different relationship, you don't pay that child directly. You pay the other parent or whoever is the custodial, who's in custody of that child. That's who you pay the support to. But with respect to the other two children, if they're in the custody of your spouse, they would get $900. That is 3/4 of your non-locality rate BAH.
So under that formula, the military member himself or herself does not get a share of that. Is that correct?
Right. And if this non-locality rate BAH is a new concept to you, you can Google non-locality rate BAH, but it does change every year. The official chart showing the amounts is on the Defense Travel Management Office website.
And for those who aren't familiar with the BAH, that's basic allowance for housing, correct?
Yes, that's correct.
That's the amount of money that a military member gets to support their housing needs for that particular month.
That is correct.
So some people may ask the question, are there circumstances where the military member doesn't have to pay this pro rata share?
Yes. If your spouse is active duty, there is no requirement to include your spouse as one of the dependents. If your spouse's income is greater than yours, again, this pro rata share formula is not going to apply, and your spouse will be taken out of that formula. And even though you may be excused from providing support under this instruction to your spouse, it doesn't excuse you from paying support on behalf of your children. And there's one more exception, and that is if you have complied fully with this instruction for a period of at least 18 months, then that pro rata share formula will no longer apply.
Now, there will be still some obligations to provide support, but just not based on this formula. Is that
Yes,
what you're saying?
That is correct.
So when do I have to actually make these payments? What is the time schedule for that?
Well, according to the AFI, or according to this Department of the Air Force instruction, you're required to make the applicable payment no later than the first day of the month following the month for which the support applies to. For example, let's say during the month of March, you get BAH, or half of your BAH, paid to you on March 15th. You get the other half for March on March 31st. And according to the instruction, you are then required to pay the required amount to your dependents no later than the 1st of April, no later than the first day of the month following the month that the support applies to.
Well, oftentimes we'll get a military member who will tell their commander, but I'm paying for other things. For example, spouse's rent or for car insurance. How does that payment play into this pro rata share formula?
Good question. The instruction actually does allow a commander to give the airman credit for certain types of support made on behalf of the dependents. The legal community frequently calls this in-kind payments or indirect support. The only types of indirect support that an airman may be credited for are only those indirect payments for housing-related costs, and only those that the airman is already legally obligated to pay under a contract. For example, if the airman's name is on the mortgage, but yet the airman has vacated the house that we're talking about, but the dependent spouse and dependent children still live in that house, the airman is providing support, not directly as money payments, but paying for the mortgage of the house that she and the kids continue to live in. That is indirect support. And the airman can also be credited for making payments on housing-related utilities, such as gas, water, and electricity. But again, only those that airman is already legally bound to pay by contract. If the dependent spouse and kids now move into a different apartment, that the airman is not legally obliged to pay the rent, then the airman is required to pay support directly to the dependent spouse. The airman can't dictate how he's going to provide support for the dependents. So he doesn't get to pick and choose what he can be credited for. And the rest of your question asked about whether or not the airman can be credited for making payments for the dependent spouse's car insurance. No, the airman will not be credited towards that. It has to be housing-related expenses.
So things like cell phone fees or expenses or internet expenses would not be covered.
That is correct. They cannot be credited for that kind of support.
Very good. Well, what if an airman says, well, I am obligated to support to the tune of, let's say, $1,200, but a particular month they write out a check for $2,000. Are they given a credit for that extra $800?
According to the instruction, no, they will not be given credit for exceeding the required amount.
So how does one communicate this issue or this need? You have a dependent come in and say, I'm not being supported. What's your best advice on how that dependent would get that information into the hands of those who can help?
Well, if the service member isn't doing what they're supposed to be doing according to the instruction, then I highly recommend that the dependent go to our office, legal assistance, and speak with one of our legal assistance attorneys who will advise that dependent, him or her, as to what they should be receiving, and they will communicate on behalf of that dependent to the service member's unit command.
Very good. Well, this has been very helpful information. Is there anything else that you would want our listeners to know at this
Yes. As the airman looks at this formula and determines that, holy cow, that's a lot of money I have to pay. That doesn't seem right that it should be that much. Well, chances are it's probably more or a whole lot more than what the state would require you to pay if you were to litigate the issue. That simply serves as an incentive for that airman to take this issue to where it really should be, and that's either in front of the courts to have them determine the applicable amount, or to settle with the dependents and sign a written agreement as to how much the amount should be. And the instruction is built for that. The pro rata share formula is only an interim measure. It's only there to be temporarily in place as long as there's not an applicable court order or written agreement. Once those are in place, then this pro rata share formula no longer applies, and the airman is out from under that particular provision. They will, however, still be required to comply with that written agreement or court order.
Well, thank you, Chad. This information has been very helpful. If any of our military members or dependents have questions about this, the recommendation, as you said, is to go to the legal office. You can make an appointment at the legal office by calling area code 801-777-6626. Thank you.